Hello, this is Alan Crone. I'm a founder and an attorney with the Crone Law Firm. And we've received some calls from clients and our friends in the community about how the new Federal Emergency Leave Act applies to businesses here in the Mid-South, and also what companies can do or should do to keep their employees safe during this time. So I wanted to record a message to everybody that hopefully is helpful in and of itself, and then offer some help on an affordable basis that you might be interested in for ongoing compliance with the law. So the first thing I want to talk about is the new federal leave package, which is interesting. It was one of the first waves of the federal response to the coronavirus quarantine situation. Since it came out, the SBA can now offer forgivable loans to help with payroll and other things. And there's some other packages available. But what I really want to talk about is this emergency leave provisions, because they are applicable to folks, and they're another tool in your toolkit to keep your business open, and how you can keep your employees, what you're required to do for your employees, but also how to keep your employees engaged going forward. And then also we'll talk a little bit about your safety of your employees. And you may have seen in the news over the weekend and this morning, I saw on the Today Show that Amazon and some other online retailers may be the subject of strikes because their workers perceive the working conditions there as unsafe. So let's unpack all of that and talk real briefly about both of these things. First is the Emergency Paid Leave Act, and the Emergency Paid Leave Act kind of comes in two. And I'm not going to talk in legalese. I'm going to try to talk straight. If you have specific questions, I'll at the end of this I'll tell you how you can call me and ask specific questions. But we're talking in kind of general terms here. Every situation is going to be a little bit different. And so kind of bear with me on that. But the first is the emergency paid sick leave. And basically this is essentially 80 hours, 10 working days of 8 hours each leave for workers who qualify. And I've got it written down over here, if you apologize my cheaters here for a second. The employees are subject to this if they are subject to a federal, state, or local quarantine or isolation order related to COVID-19. In other words, they can't come to work because of it. So under most of these safer at home issues, if you're an essential business and you're open and they can otherwise telecommute or come into your place of business, then that wouldn't apply to them generally. The employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. And again, and you can require to receive a written certification of that healthcare provider notice. So this isn't just going to be, I think I may have been exposed, or I'm concerned about exposure. This is a healthcare provider ordering someone to stay at home because they've been exposed or they're showing symptoms, et cetera. The employee is experiencing symptoms of COVID-19 and seeking medical diagnosis. So again, I think maybe I'm an employee and I've got I got respiratory problems, and I've got a fever, and I think I may have COVID. I'm going to be off a couple of days to go seek a diagnosis. And then once I get my diagnosis, let's say that 2 days goes by and I get a diagnosis that says I'm negative and I want to come back to work, then those couple of days that I was off seeking the medical diagnosis probably going to be compensable under this leave provision, but they come to work after that. If the employee is caring for an individual who's subject to a federal, state, or local quarantine order, or the individual's been advised to self-quarantine due to concerns related to COVID-19, that's the same there. If the employee is caring for the employee's son or daughter, if the the child school or child care facility has been closed, or the child care provider is unavailable. So if the employee calls in and says, hey, I can't come to work because I don't have anybody to keep my kids, then they're entitled to these 10 days of paid leave. And again, the paid leave is $550, $500 a day, capped at $5,000 for the period. The employees caring for the son or daughter, the employees experiencing other substantial or similar conditions specified by Health and Human Services in consultation with the Department of the Treasury and the Department of Labor. That's a catch-all that will be defined by regulation as we go along. And so this also applies if they get COVID-19, the employee directly, then they're entitled to the 10 days of leave. Now, they're also entitled to a reduced amount of leave or reduced amount of pay, $200 if they a day, that can go for a much longer period of time, a total of $10,000, which is several weeks, if they're caring for children that are at home because of their school has been closed as a result of COVID-19. So you want to have policies that clearly articulate when people are entitled to leave and when they're not entitled to leave. Now, this applies to companies of 500 to 50. Now, if you have 50 or less, then you can apply to the Department of Labor for a waiver based on financial hardship. And the last time I looked, the Department of Labor had not yet put on their website a means to do that, or any regulations that deal with that. Now, this probably going to take a couple or 3 weeks for the Secretary to establish rules and regulations on this, and maybe about that long or longer before there's stuff on the website to make these applications. Now, the Department of Labor has clarified that these leave requirements went into effect the day they were passed. So they're in effect now, and they go until the end of the year right now. Now, they can be extended, but these people don't have to have worked, under the Family Medical Leave Act. They have to have worked for a year before the Family Medical Leave Act applies. Now, everything that applied under the Family Medical Leave Act, that's still the case. Somebody comes to you with a medical condition that would otherwise qualify for the FMLA if you've got 25 or more employees, and the FMLA applies to you, then you process that as you normally would. This only applies to COVID-19 situations, the ones that I've outlined to you. So again, it's a case-by-case basis. You have to be very careful on how you deal with these things. The other thing I wanted to talk about is some guidance on safe workplaces. There's lots of interest in this. I've gotten lots of calls from both workers and from small business and even large business owners on how do we do this. I think the first line of defense is the OSHA has issued some guidelines, and those are good to go look. You can find them on their website. They're fairly easy to read, and basically the OSHA guidelines basically require social distancing and all reasonable efforts that as a business owner you can make to keep people safe, and that is observing social distancing both in terms of between coworkers, but also in terms of the general public. I know there's some grocery stores, for example, that have erected plexiglass shields in front of the cashiers and other people who have to, deal with and interact with the public to prevent transmission, and they wipe those shields down frequently. Another thing that OSHA recommends is frequent sanitizing of surface areas and common areas and areas where people are interacting, both in terms of coworkers and maybe the general public. As much as you can do outside, if you're a restaurant and you're having people come to your place of business to pick up orders. If you can do some of that outside, I think that's advisable. I think with a lack of specific without specific guidance on a specific situation, I would say, generally speaking, you've got to be reasonable and you've got to take reasonable care. That's just kind of basic tort law 101. And so you want to make sure that you're doing everything you can to prevent the spread of the disease on your premises, whether it's to your coworkers or to vendors or to the general public. And so that means social distancing. It means increased sanitization, cleaning, having hand sanitizer available, having Clorox wipes available, maybe even having PPE available, personal protective equipment. If you can find N95 masks or surgical masks or other barriers that prohibit contamination person to person. Those are all reasonable steps that you should take. If you're, I think this is also good business. If you are providing people with a package, you may want to conspicuously wipe it down before you hand it to them so that they know that you care about their health. And I think that's good business. And I think it's also good from a legal liability standpoint. Now that's kind of briefly some FAQs, some frequently asked questions on both of these issues. We had a meeting here at the Crone Law Firm over the weekend, and I asked our folks to think about this. I said, look, I want to help as many people as I can. I want to answer as many questions as I can, and I want to make it as affordable as I can for us to give value to clients and potential clients, but also to keep our lights on. So what we've done is for small businesses, we've established a $350 coaching package that includes a call with one of our lawyers to talk about your COVID-related questions, particularly as it relates to leave and to working conditions. And then we would help you craft an emergency policy that would cover your leave situation to make sure that your leave policies and procedures comply with the new federal requirements. And hopefully that will get you a long way down the road for compliance, and we can all get to a point, hopefully as soon as possible, where we don't need to do all of this stuff. And as an employer, you can really play a pivotal role in that, in helping end this disease by practicing these social distancing practices in your business and help stop the spread of the virus. And that's really the best thing that we can all do. I can tell you here at the Crone Law Firm, we're monitoring OSHA. We're monitoring the Department of Labor, both state and federal, for new guidance, and we're going to push those out on our website and via email and social media so that people know the latest and greatest developments. So on this page that you're looking at, you should see our phone number and a contact form if you want to set up one of these coaching sessions. I think it's a great investment for the safety of your business, but also a great investment in our community health. So again, I'm Alan Crone. I really appreciate your time and your attention on this. And if we can be of service, please call us and let us help you. Thank you, and stay safe. And I look forward to seeing you out at a Tiger game this fall. Thanks.